7 people are waiting in that. Oop, phone is going off. Let's see. Shut up. Really? What the? Ow. Wow. That MFer. Hi, Brandy. How are you? I'm glad you made it. We are just awaiting. How'd the dentist go? Hi, Joanne. Glad you're here. No cavities. That's good. Good news. I hope that starts the trail of good news today because we want good news. Oh my gosh, are you serious? I hate the dentist. That's like my least favorite doctor to go to. Ugh. Mm-mm. Not for me, man. Yes, we're waiting for them to start, Joanne. I'm pretty confident they are not going to retry him. It is a constitutional it's in the Fifth Amendment. You absolutely cannot retry him because they found him not guilty on the first charge. The other charges are just the same charge basically, and they can't retry him. So this is a double jeopardy. Also, I don't know if you guys saw my videos, but there is another guy who has been charged with deleting the doctor. Hi, Ryan. I know, Ryan, I am too. Oh, FYI, you guys, I just want to tell you, they took down my GoFundMe again. I apologize. But his attorneys and I are going to think of another way to start a GoFundMe, which really irritates me. They told me that it was because you're not allowed to do a GoFundMe for like legal purposes, legal reasons, which I wasn't doing a GoFundMe for legal defense or anything, but that's what they said. But really irks me because you guys, I don't know if you knew about this or not, but you know Wade Wilson. These women are disgusting and sick. They have started a Fundly. I don't know if you guys have heard of Fundly. I'll put it in the comments. But there's a Fundly. It sounds kind of fake, but anyway, they started a Fundly for Wade Wilson, and they have raised $55,000 for Wade Wilson. They are so enamored by this man that they have raised that much money for him. So on Fundly, I can start that and I can raise money, but I mean, it's just insane that GoFundMe. Yeah, so his attorneys and I are going to try to work out something else to try and raise money for him because I gave the money that was made. It was only $80. That money's already gone to Tierra. So I just feel badly because I feel like I failed, but I don't know what else to do. That's 2 times they've taken it down because I guess I shouldn't have called it justice for Michael Jackson Bolanos. I don't really know what I could say. They don't want it's so weird because like during all the Minneapolis riots and all the riots they were having, like they were putting GoFundMes up to get people out of jail, like raise bail money for these people, and these people were burning buildings down, and GoFundMe didn't take those down. So I don't know. I just feel like I failed on that aspect, but I'm just going to keep trying to work hard on the other things that I'm uncovering, you guys. And let me just tell you, this case has taken me down rabbit holes that, I mean, wow. Yeah, it's insane. But I have discovered quite a bit of stuff following the money trail. I mean, you just have no idea. I do, Ryan. I do think that after this, as far as Michael's part is concerned, I think that this will be done. But for Samantha, hi, Gwen. Welcome. How are you feeling? The judge is just not experienced, but she has to follow the law, Ryan. She has to. She has to follow the law and the Constitution. The Constitution supersedes everything. I mean, even her. And even though Michigan does give some leeway to the judge as far as sentencing and all that, I looked up the sentencing for even the lying to the police thing. It's a misdemeanor. And it's the most he can get is 93 days in jail. And it's she can't. I don't know where she came up with this 15-year thing, because I looked it up, and even for a felony is 4 years. And so I don't even know where she pulled that number out of her, like out of thin air. It's just weird. So I will tell you guys, Jeff is in the courtroom. He's sitting next to Sam's dad. This is so odd. I mean, so odd in so many ways. So many ways. This case, you guys. I don't know. I wanted to go to Detroit. I looked up plane tickets. Would you believe, you guys, plane tickets to Detroit were $800? I'm like, who the hell is on purpose going to Detroit? I was like, what the heck? Yeah, right, Ryan? I'm like, I mean, it's so weird. That is so odd. Sorry, you guys are going to hear my phone going off probably. Right? Ryan. I mean, I wanted to be there for Tiara in court, and I wanted to be there for Michael. I wanted to be sitting there. But when I looked at the ticket prices, I was like, holy crap, I just cannot. I mean, that's money that I could use for, to give to Michael, or, to like help do more investigating for this. But I mean, to go to Detroit, I mean, my gosh. I know. Yeah. Yes, I got it waiting. That's why I have it pulled up on my screen. I'm waiting for it to start. So we're just waiting patiently. So yes, Ryan, we are awaiting. Whew. So I am going to do my Murder on Juliet Place. I'm going to make it much more I don't want to say scripted, but much more, I guess, scripted, for lack of a better term, series, and much more detailed now that I know a lot more about this case and what's going on. So I am going to do a podcast / part of my YouTube, but it's going to be much more scripted and a lot more detailed about, the synagogue, the money, Samantha. I've reached out to a lot of people. I even called Jeff and left him a message. Hi, Kirsten. Welcome. Guten Tag. So yeah, we'll see. But he hasn't called me back, obviously. So I told him, I wanted to get his side before I told it for him. So, I can just tell him the side that I think his side is, if that's what he wants. But I bet you have, if you were in Detroit. I mean, I talked to Tiara while she's walking in Detroit, and all I hear is just like, oh, it's scary, freaky scary. So I'm pumped, y'all. I don't know about you guys, but like Ryan is like sweaty palms. Like I'm just like, chatty Kathy right now because I don't know what else to do with myself because I'm just so nervous. So yes, her family is very misled. I just think it's so sad. I don't know how Jeff is going to go to a synagogue that's going to have her name on it. You know, I mean, I don't know how he can possibly sit next to her father. It's just weird. I mean, it's just so insane. No. We're still waiting, Kirsten. Yeah, it's just crazy that this is even happening. And so I know you guys know about the Dr. Hoover deletion, right? Like they found the guy, or supposedly, allegedly, have the guy who did that crime, and he got $1 million bond, and he has actually been convicted of deleting someone before, and he gets $1 million bond. So yeah, and Michael didn't get a bond, right? But that's so strange. Like, ew. Like, that guy was rich as hell. He could have had anybody he wanted. I don't understand why he messed with this weirdo. So I don't know. I really can't wait to find out what kind of evidence they have, because I'm really curious if that's how it really went down. I'm just curious. I just want to know, like, if that's what really happened. So, oh yes, he can definitely appeal. He definitely has room for appeal. He has appeal after appeal after appeal on this because they allowed so much in that shouldn't have been allowed in. There's just so much. I don't know if you've watched the videos that I've posted, Ryan, but Ryan Elsey. His name is your name, Ryan. Ryan Elsey, the prosecutor, is no longer on this case. He now works for the Department of Justice. I don't know if I told you guys that, but he works for the Department of Justice now. He got that job while he was working on this case. Believe it or not, they're all connected. Yeah, so it's all connected. It all goes hand in hand. It's crazy wild, but he actually told the judge and all the attorneys the day the trial started that this was his last case with the state. So, doesn't seem kind of odd. Why would you tell them that anyway? Why would you tell them this is your last case the day of the trial? Isn't that weird? I think it's kind of weird. I'm going to refresh it and see if it started. No, nothing yet. Okay. Oh, and Ryan, I don't know if you saw, you weren't here for, we did a live the other day. Guess who Patrick is? Do you know who Patrick is? Were you ever in the Fox chat? The Detroit, this chat up here? The Patrick guy who was like hot and heavy all over Michael and just kept saying that Michael was guilty, 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 and everybody kept calling him Jeff because they kept thinking that he was Jeff in disguise. No? Well, I found out who he really is because he started trolling me on Facebook. He works for the Attorney General's office, who is Dana Nessel. And who is Dana Nessel? Well, Samantha got her elected. Samantha worked on her campaign. So Patrick, it's like so weird up there. It's like such a incestual situation going on in Detroit. I know, right? Yeah, he hasn't said another word. I outed him on Facebook. I outed who he was, and and he kept asking, because he was like, if you have so much evidence, why don't you put it on Facebook? Why don't you do this? Why don't you do that? And I was like, just go to my channel. You can see everything you want on my channel. So finally, I was like, fine, Patrick, you want evidence? Patrick wants evidence all the time. So I posted his LinkedIn page on Facebook and said, here you go. Here's your evidence. Patrick works for the Attorney General's office, who's Dana Nessel. And if Patrick wants evidence so badly, he can just get it from the Attorney General himself. Boom. There you go. And everyone on Facebook was like, oh my gosh. Figures. That makes sense now. So, and he hasn't said anything since. Hey, trial junkies. Man, don't mess with me. Like, seriously, I have been investigating this hard and heavy. I don't appreciate that. Yeah, he hasn't said a word, Kirsten, right? He has not been on anything. He was a top contributor too, and now I'm a top contributor. Yeah, he has not said a word. I mean, it's public information. It's not like it's that hard. I mean, duh. Hey, LaDonna. I don't think so. It should go pretty fast. I mean, I hope it doesn't go as fast as the last one. My God, she was like 30 seconds. We're out. So it's just all the shadiness going on. Hi, that's my Juma, Marianne. Hey, Mama. See, now you see what I'm doing. That's why I can't be up there right now. I love you. I don't know. Honestly, Kirsten, like they're so dead set on Michael, but they know. They know. And also, did y'all know that the Wall family is the one paying for the synagogue to be renamed after her? So, that's a lot. Hi, Jessica. What? Are you serious? Oh, yeah. Oh, you're right. They did. I just got the message. We have to wait another hour. Wow. Is the Karen Reed thing going on right now? Are they having the hearing right now? Let me look. Oh, they're at lunch for Karen Reed? Why are they putting it off till, oh, man, dang. Oh. Oh, LaDonna, you're in Philly, right? Oh, so 30 more minutes. 30 more minutes, y'all. We can chat for 30 more minutes. We can get through this. We've done this before, haven't we, LaDonna? LaDonna, I hadn't heard anything smart come out of your mouth yet. That's what we say. If this stinks to high heaven. That's right. Girl, I knew you had to bring. Why you gotta bring that up? Why you gotta do that? It ain't even football season yet. Don't even go there. Oh, Sarah Boone was in the courtroom. She got her motion granted. She doesn't have to wear handcuffs. She doesn't have to be shackled in the courtroom, and she gets to sit at the defense table. She doesn't have to sit in that chair in the jury box. So she's actually getting some stuff that she wants. So yeah, it ain't football season, LaDonna. I don't want to hear that shenanigans right now. What? They play tonight. Oh dang, it is football. It's August. Holy moly. Ooh, that means college football starting. Woo-woo. That's right. War Eagle. Oh yeah, she didn't get that. Honey, she don't deserve that. She blew that chance when she got it. This case is going to be a debacle because she does not know what she's doing. It's going to be hilarious. I don't know if I'm going to be laughing the entire trial or if I'm going to be pulling my hair out when we watch this trial because it is going to be one hot mess of a trial. I just don't know because she is dumb. I'm sorry, Lord. Oh man, Ryan, I'm telling you what, that woman, she keeps like looking to the judge to like give her advice. He's like, I can't tell you anything. I can't give you any advice because you decided this. Oh yeah, but because she's been through 8 attorneys. Yeah, at some point, yeah. Well, she wasn't using a small voice when she put that man in the suitcase. Sarah, I mean, it could look premeditated. I don't know. Honestly. I don't know. That's tough to say if she intended for that to happen. But yeah, I mean, I don't know. Yeah, the taunting. But does it mean that she wanted him to go away? I mean, I don't know. She did. She was vengeful. I mean, was she? I mean, I don't know. I don't know how to look at that. I mean, he did. I don't know. I don't know the whole story. She says that he beat her and cheated on her. Um, I mean, I don't know. They had a very volatile relationship. They both were charged with domestic violence. So it does seem dumb that he got in there. I mean, I'm just shocked that a man could fit in a suitcase. That's my thing. Yeah, true, Ryan, but they, yeah, yeah, he was a very tiny guy to fit in a suitcase. No, she didn't. Did she? I did not see that, Kirsten. I can imagine her being that way, like yelling a lot. I can see that. I could see her being a yeller. Yeah. Yeah, the I mean, cuz think about being like bunched up in a suitcase like that. Like yeah, you probably couldn't like you couldn't breathe. Like you're all stuffed up and he had to be in the fetal position, Like it had to be hard to I don't know. I think it's a terrible way to go. That to me like that and drowning or fire, that like scares me. I would hate those ways. or slow torture. That's interesting. I'll have to look that up. I wonder. Why would you put your child in a suitcase? I know, right, Brandy? It's like, ew. Yeah, those are the three ways for me. Like, I'm afraid of water anyway, so that would not work jive with me. But like a fire for sure, like not for me. And then like I can handle, like, it's so weird. I can handle crime cases, and I can handle seeing all kinds of things in true crime. But man, human torture. Mm-mm-mm-mm-mm. What state is she in again, y'all? Well, let me look up what states have the DP. I honestly, y'all, I'm gonna just tell y'all how I feel about the DP. I think it's a waste, to be honest, and I don't think it makes anything any better. To be for real, like, people sit on DP for years, years and years and years, and we're still spending all of our money um on these people. Oh, Florida does have the DP. Okay. But the thing is people sit on that wing for years, and it sometimes they just end up going away without the DP. So I don't think it makes any sense. I think it's a waste of money, and I think I don't think that it holds any more bearing than the life without parole. To be honest, I don't think it matters. And also, I think God says, "Vengeance is mine, saith the Lord." And I feel like uh, it's God's. God will get his vengeance, and it's up to him at the end of the day. Oh, what? What? Kirsten? That's weird. You know, she probably does, because Wade Wilson does. I don't know if you heard me earlier, but Wade Wilson has a little fan group that has made $55,000 for his um fan club. They've made him $55,000. Can you believe that? Holy moly. That's a lot of money. Yeah, it's disgusting. It's so gross. These people, have y'all seen the TikToks of that guy? They have him walking into the courtroom with some music and stuff. Like, he is like, ew, ew. It is so disgusting. But yeah, they've raised $55,000 for him. And I only got $80 for Michael. So weird. So weird. Ugh. Ugh. Lots. It's so gross. I don't get it. I do not get it. I mean, and then I've been hearing some of his jailhouse calls. I can't even listen to him. Like, it's ew. Mm-mm. It's weird. People are weird. I mean, I'm sorry. I hate using that word because they're using it so much right now, because they're calling all Republicans are weird. Okay, everybody's weird. All right, everybody on the planet is weird. Just so you know that. But that whole situation is it's got you. I would want to say it's an anomaly, but I don't think that it is. I honestly, like, look at Ted Bundy. Well, honey, Gwen, I'm sorry, but I think it's fallen on deaf ears, because uh he is, I don't know. Ew. Ew. Who's saying that? Yeah, but he said on the phone Okay. I just got a funny message. This is you're a weird. We are weirdos, Brandy. We're such weirdos. The fat lady didn't get her lunch yet. That's why they put it off till 1, y'all. Sorry. I'm not going to go to hell for that. That was mean. That was mean. Well, she has to eat. We all got to eat, okay? Nope, no one can say you didn't try. Gwen, I prayed so hard for you last night. I just want you to know I prayed and prayed. I prayed last night till I fell asleep. So I prayed and prayed for everybody here. I prayed for all of y'all last night when I was praying for Michael. Hey, David, God bless. I prayed for David. I prayed for everybody. Because I needed all y'all to be well and be here so that we could send positive vibes to Michael. David, I don't know if you heard, but Jeff is in the courtroom sitting next to Sam's dad. What in the world is happening right now? Are we in a multiverse or something? How crazy is that? Oh my gosh, we're in the Matrix. It's just insane. They're going to start at 1. I know, right, David? I love when you say God forbid. I love it. I love it. It's one of my favorite things about David. I know. He's sitting next to Samantha's dad. It's insane. What is happening? I feel like we're in some sort of like... Yes. I know. Come on, Trial Junkies. You know I can't go a day without mentioning Keanu. My dang dog's name is Neo, okay? They have to. They have to let him go free. They have to. She has to. It's unconstitutional. I mean, like this is a constitutional it's a violation of his constitutional rights if they do this. And they know that. And I've talked to several attorneys in Detroit and I have and they know, the prosecution knows. The prosecution knows they're wrong for this. Speaking of Keanu, LaDonna, did you do your homework? Aha. Yeah, that we could talk about that. Where's LaDonna at, huh? Now she's hiding. Talk about them dang Steelers. She don't want to talk about her homework she had to do. She had plenty of time to get it done. Are you kidding me? During the fall or winter? Honey. Ma'am, we're going to have a talk. You have to go to the principal's office. Trial Junkies, I need you to get on her. Who are the Lions? I don't even know who they are. Who is that, Brandy? What are you talking about? I'm San Fran all the way, y'all. San Fran is finally going to Home Depot called. What? No. Ew. Whatever. that San Fran is going to win the Super Bowl this time. Finally, they're finally going to win. They're not going to fake it up to the final Super Bowl game. Look, let me tell y'all something. I want to tell y'all how football works, okay? My boyfriend tells me this is not how it works, but this is how it works. And I know this is how it works because this is why my 49ers lost. Because I don't watch the games, because if I watch, then they lose every single dang time. If I watch the game or if I watch a play or whatever, my team will be winning, like Auburn almost beat Alabama. But as soon as somebody came down and was like, oh, your team is winning, they're doing such a good job, literally in the last seconds of the game, they lost. That's how football works, y'all. Don't tell me about the game. Don't watch the game. Don't tell me about the game. Don't nothing about the game, okay? That's the exact same thing that happened to San Fran and the Chiefs. San Fran could have won that game, but people had to come and tell me about the dang game. I flew all the way to New Jersey to watch the San Fran game, not to watch it, but to be there with my nephew because we're both San Fran fans. And we did not watch the game, but everybody kept calling and texting and talking about the game and all this stuff. And we were like, no, we don't want to hear it. And guess what? They lost. What did I say? The same thing happened the year before because my boyfriend watched the last 20 minutes of the San Fran Super Bowl game. And I told him, do not watch it. And then they lost. And of course, I blame him for losing. And then my Neo dog, we wore all of our Auburn shirts when Auburn was playing Alabama a couple years ago. And Auburn was winning. Yes. And my Neo got all pissy about his shirt. And he wanted his shirt off. And he took his shirt off. And I said, if they lose, it's going to be your fault. And I have blamed this dog for that loss for the last 3 years. So don't think I won't blame one of y'all if y'all tell me about a game if one of my teams lose. Look, ma'am, San Fran has been my team since I was a kid. Joe Montana, Jerry Rice, best duo ever. So that's who I'm with. Karen Reed, I hear noise. Let's see what's going on with Karen Reed. What's the noise all about? Oh, it's there's some movement. Nothing yet, but there is movement in the courtroom. Free furniture if the Lions win. It's probably crappy furniture. I mean, it's Detroit. Look, that's how football works. I'm just telling you. And I'm right. My poor little Neo dog. He's been blamed for that loss for so many years. Look, I have to have something to go with, okay? Because my poor team, Auburn, is going to take years to rebuild, okay? Years. Bless their hearts. I just don't know. I mean, we're still paying off coaches from years ago. Our program is just screwed. Okay, I'm gonna need this court hearing to let's go. We got to let Michael go. Come on, people. I'm gonna refresh and see if they are gathering or not. There's only, I'm trying to read some of this. Oh, they're calling somebody else, Jeff, in the chat. I'm gonna write in the chat. Okay. I'm sorry. Stealing Nick Saban. First of all, he coached Alabama, ma'am, sir. I don't know. Are you a ma'am or a sir for Trial Junkies? Explain it. Trial Junkies? I'm not an Alabama fan. I'm an Auburn fan. You got me confused with somebody that is retarded. I mean, okay, thank you, ma'am. You got me confused for somebody that doesn't have a brain. I'm an Auburn fan, not an Alabama fan. Let's not get crazy, okay? Yeah, we no. See, Auburn fans love their coaches, and we remember our great coaches. Unlike Alabama fans who replaced their greatest coach ever, Bear Bryant, and got Lord Saban, and now they don't even know who Bear Bryant is, which is really sickening and sad. See, that's Alabama fans for you. I don't know. Should I be asking people what your pronouns are and stuff? No, I'm not doing that. I'm just kidding. I'm totally kidding. We don't do that here. On the alternate point of view, just so you know, I'm not doing that. I'm sorry. I'm sorry. Just, well, I also identify as rich, but none of you guys. Yeah, there's moving in the courtroom. They're just chitty chatting. What's his name is not there. Her other defense lawyer. What's his name? The little short guy. Darn it. What's his name, y'all? I'm having a brain fart. Jackson. Alan Jackson, because he's got the same name as the country singer. He's not there. Yeah, I got it now, Trial Junkies. I already got it. I said it before you even typed it. If you weren't a cat, you could have typed faster. You had opposable thumbs, but you don't. So there you go. Okay, so let's see what's happening with. I don't see the judge yet and Karen Reed. Nobody's in there. I don't even see the defense. They're not up there yet. Ow. Okay, look, we're not going to start some kind of furry club here. That's not happening. So if you guys want to start a furry club, y'all are going to have to create your own YouTube weirdo channel. I mean, yeah. We're not doing furries here. Woo! John O'Keefe's mom, man. Looks could kill. Yeah, they're all starting to pile in the courtroom. Hey, they did say something about Michael Proctor. His his other cases are starting to come into question now. So, I mean, he's in big trouble. Oh, nice. I want a celebratory gummy. I'm going to see my mom's coming to get me after this. I'm going to go hang out with her this afternoon. My local mom. No, that guy's been a bad apple for a long time. No, I can't. I can take a half of one. Oh, y'all, since y'all are all here, because I'm sure you're just dying to know about my personal information, but I finally have answers for the pain that I have been suffering for so long, and I'm going to have procedures done to take care of it. So it's so weird and random. But, oh, also, by the way, y'all, I just want to tell y'all this funny story. So I went to the doctor yesterday. My boyfriend went in there with me, which is kind of embarrassing because I had to pick my eyeballs up and put them back in my head when my doctor came in because holy bananas, he was so hot. Oh my gosh, man, I don't know what he said. Actually, I have no idea what anything that came out of his mouth other than, I mean, he was just so hot. I don't even know, but honey, I wish Keanu was my doctor, but this guy was he was it was a good compromise. I'll just tell you that right now. When he walked in, I'm telling you, I was like mesmerized. He had, I don't know what Asian descent he is. Like if he's, I don't know what, but he had the most beautiful brown eyes. And my boyfriend's sitting right there. And the whole time I'm thinking, good Lord, I look like I just rolled out of bed. And this man comes in here and I literally look like he had to touch my butt, y'all. And he had the nerve to ask me if I had been active lately. And I was like, dude, you just touched my butt. You know, I have not been active lately. Okay. Did you feel how soft that butt was? That was not an active butt. Okay. But anyway, he finally explained to me what's wrong with me. I have nerve damage. Okay. Right. I mean, y'all, whew, man. Okay. Look, I even have a picture of him because he's so dang hot. I don't even know. I can't even with this guy. But anyway, he's going to have to do procedures on me. And I'm going to have some nerve blocks done because that's what it is. It's nerve damage. Y'all, look at my doctor. Do y'all see this doctor? Why is this doctor so hot? Why does he have to touch my butt? That doesn't even make any sense. That's why. What? Anyway, the pain in my side is not my liver. Thank God, it's not my liver. It is nerve damage. I have so I have to have some nerve blocks done. So yeah. Well, when you see him in person, oh my gosh, y'all, I couldn't even. He was way hotter in person. Way hotter. His eyes were just giant, huge. I mean, I don't know. My boyfriend, when we got in the truck, he was like, I cannot believe you. He goes, you didn't even try to hide it. I was like, oh, man. Anyway, but yeah, so next month I'm going to get these, and I have to be knocked out for these procedures, y'all. So I'm getting these nerve block things done on my ribs and on my left butt cheek. Yeah. I know, right? It's funny, but it's not funny, but it is funny. But it was funny because I didn't hear a word he said. My boyfriend clearly listened to everything he said because he was like looking up all the terminology on the internet. I don't know what that man said. Because I was literally just mesmerized. So, oh, good. Did you have a good MRI come back? Oh, are you serious, Trial Junkies? Oh my gosh. I tell you what, man. These doctors are just getting younger and younger. I mean, I might have to have more pain. I might have to be like, I have pain here and here and here. Oh, what are they going to do about it? Well, it's too late now, lady. I done bought a sofa. Oh, I know all about the hot dentist too, man. Kirsten, I would go back to Alabama to see my dentist. That's how, I mean, it was wrong. He was a good Christian man. But I would literally fly back to Alabama just to see my dentist. It's terrible. You know what's crazy is I only trust the Asian doctors because they're the only ones that give me answers. Yes. He finally is going to help. Yes, I'm finally getting help. So, I mean, I might need mental help now. Yes, a good dentist is very important. But a hot, good dentist is even more important. Right? I know. Ryan, do you have a hot female doctor? Because, I mean, I know you're feeling kind of like, why are y'all talking about hot doctors? But, I mean, a doctor is very important. You got to be very picky about your doctor. And if they just happen to be hot, then, I mean, they're probably gay. I'm just going to say that. That's what we say. They're gay. Yeah, I truly, literally, out of all the doctors I've seen, the Asian doctors are the only ones that have given me answers. The white doctors don't know jack. And that's not being biased or anything because, you know, being Asian, but it's the truth. Yeah. Now my coffee's cold because I'm talking about that hot doctor. Oh, all right. So yeah, my dentist. Okay, hold on. While we're waiting for Michael.
Now, and again, it's in the context of double jeopardy, which is such a historic and important clause that was enacted by our founding fathers to give them some
protection. You're so funny, Child Junkies.
Against simply choosing to mistry prosecutions that weren't going well. And the founding fathers wanted citizens not to have to face re-prosecution.
This is Karen Reeves.
They understood the ordeal and anxiety and risks of having to prove to a second jury what they had proven to a first jury, which is that they were not guilty. And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty? What can we do on August 8th, if I've got the date correct? 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury. And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all three counts when four jurors are saying they were not, and a fifth juror is saying.
That's why he understood her like no other man, Kirsten.
We have to embrace the fact that these are now facts. Yes, they come after the end of the trial, but it doesn't mean that
I don't know who this guy is.
Procedural pathway to integrate those facts into Your Honor's decision making. The second one, the manifest necessity issue, has got a lot more SJC and Supreme Court guidance. It's been the subject of lots of cases. We're walking a little bit down a pathway that has some precedents about jurors and they being reconvened, but it doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that will address that. But here what we know is that four jurors reached out to defense counsel. Jurors A, B, T, and E, I think is the way they've been described by Mr. Jackson, who received calls from three of the jurors, and Mr. Yannetti, who received a call from one juror and talked to somebody who himself or herself spoke to a fifth juror.
Okay, it's for the defense. Okay.
We also have the corroboration, not just internally, with these four jurors.
Oh, he's a big top defense.
Essentially saying the same thing. We reached a decision. We didn't denounce it. Some said we felt bad about it. We didn't know what to do. But they're internally consistent and not self-contradictory. And that makes them more trustworthy. They corroborate each other. And I contend that the voicemail left on Mr. Lally phone, which he responsibly shared with counsel and shared with the court, essentially saying this was probably one of the four jurors, but we don't know for sure, says essentially the same thing. We reached a decision that Ms. Reed was not guilty. Murder, the most serious charge that can be brought, a charge that would imperil the rest of her life if there was a conviction. Other jurors tried to reach the prosecutor. They didn't succeed. The prosecutor made a decision that he couldn't promise anonymity, which every juror seems to want, and that's understandable given the level of media and public attention on this case. And I understand the court gave them discretion, and Your Honor made an order that the defense didn't dispute that they were entitled to anonymity. The public interest did not weigh the interest of the jury in anonymity. But we now have the declarations of the jurors through the defense counsel. We have a voicemail of one juror through Mr. Lally. We have emails of other jurors who only wanted anonymity as a condition precedent to talking to the prosecutor. This case, because it has catalyzed so much publicity, it's plausible to believe, if not compelling to believe, that other jurors who sat through so many weeks of testimony, this was probably one of the monumental central events of their life. Not many people, certainly not people who go, other than people who go into military service, have opportunities to serve their community like these jurors did. Not one of them, to our knowledge, has picked up the phone to defense counsel and said, those jurors that you're memorializing in affidavits and in motions, I don't agree with that. No one has called the district attorney. Nobody has emailed anybody. Nobody has called Your Honor through the court clerks. Nobody disputes, in other words, none of the 7 or 8 jurors that are not, represented by the series of affidavits of defense counsel dispute the truth of the representations made by counsel. We don't have certainty. We only have the reasonable inferences from the absence of other declarations, which is that this jury was unanimous in its acquittal of Ms. Reed on counts 1 and 3. So then we get to the legal issue, and again, as I tried to say, the legal framework here, the landscape is not quite as crystal clear as it is in standards of manifest necessity, whether or not double jeopardy permits a re-prosecution in the context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form of a judge's actions. We're not bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, form is not
Sorry,
to
I'm
be
working on
exalted
something
over
else.
substance.
Trying to get us into the courtroom.
They are making that point. I mean, I've done this for 52 years, and the procedures important to inform sometimes.
Still at lunch.
And it's the recognition that double jeopardy is different. For instance, as I'll get to in the manifest necessity phase of the argument, all of the courts put a heavy burden on the prosecutor to justify a mistrial, to justify a re-prosecution. Ordinarily, I'm used to the burden speaking on me as a defense counsel. I'm used to having an affirmative obligation to lay out for an appeals court exactly what I want. But in this unique area, the disincentive to re-prosecuting somebody, the same prosecutor for the same offense.
There's a way to get into the courtroom on a Zoom, so I'm trying to get on the Zoom.
It's so significant, it's so core to our values that they put the burden on the prosecutor, and I will get to the cases that support that, what I call the central proposition, which is, where's the default? Is the default from not asking the jury about these other counts that Ms. Reed goes to trial again? Or is the default instead that the prosecution simply cannot again re-prosecute her when it was not manifest necessity in the first place for the counts 1 and 3? The Supreme Court 67 years ago, I remember it because it was the tail end of the Warren Court. And it revolutionized criminal justice. And it talked about Miranda rights. Nobody knew.
Okay, so
back in the 1950s.
I'm trying to catch up on y'all's chat.
Gave right to counsel rights. Matthew, Ohio extended suppression remedies for 4th.
Okay, I'm in the Zoom. Hold on.
Nope. Until the Warren Court. The Warren Court, in the case of Green versus the United States, and it's in our pleadings, said, and it's important, that double jeopardy was designed to protect an individual from being subjected to the hazards of trial more than once. That the state with all its power should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a world where we have facts not known on July 1 that are known on August 8? And we're not, this is not completely novel territory.
I have way too many things going on. I have, I'm entered into the Judge Van Houten's Zoom chat. Zoom room. I'm in the Zoom room.
Punishment with whether the punishment should be life or death for the Sanaya that was arrested and survived. And they recently, in a lengthy opinion of over 100 pages, said bring back these two jurors where we have a principal basis to question their impartiality. The SJC just 4 years ago in a case dealing with a lawyer's allegation that there had been a racial statement. It's called the McCallum case, 485-90. Said to the defense counsel, the judge will authorize you to recontact that jury.
Oh, I'm in Judge Van Houten's Zoom room.
If there's any skepticism
in the Detroit court.
We will have a hearing and make decisions. The nation was affixed to the Murdoch case from South Carolina, where a lawyer was accused of killing his family. And there was evidence recently, according to the media, that a clerk spoke to a juror, and the judge convened a hearing, questioned the people who were connected to it before in order to make a decision.
She's not on yet.
Regularly, judges.
So it's not the Fox News.
Reliable evidence.
She's not there.
There was extrinsic evidence that a marshal talked to
She's still eating.
Was a juror bias? Was the questionnaire fair? Did something happen during? Did the jurors access the internet when they were judicially prohibited?
Well, okay, LaDonna.
Courts.
You want a cookie? I can't give you one.
And I can test that it can be done anonymously.
You know what? I'll give you a smiley face.
To the jurors. And we're going to ask the court to do just that, because
there.
Without in any way diminishing the
I don't know what that is. It's supposed to be a smiley face.
Jury that tells the truth on voir dire. It's not ethnically or racially biased.
Are we in a race?
There's nothing more central about.
I know, right?
Making sure that jury was not influenced adversely by something from the outside or even by something from the internal discussions that reflected on a juror's racial and ethnic.
You should be ahead of me. You're an hour ahead of me.
Impartiality. Why isn't an acquittal entitled to just the same kind of deference? we have not evidence that the jury was not impartial or that they were influenced externally. We have hard evidence that they reached a decision. We're not asking to have any inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them. Which is, did you reach a verdict on count one? What was that verdict? What about count two? No. What about count three? Yes. So there is precedent, although slightly different, but we contend no less important.
I know. I've already given her homework and she hasn't done it, Kirsten. So don't give her anything.
A decision.
She's lucky she got that smiley face out of me.
In any way of the attorney's declarations, if you cannot accept them because they're not the sworn affidavits of lawyers, of the jurors. Sorry, we authorize them to do what they haven't, which is to reinitiate a call to these 4 or 5 jurors. Ask them whether they would read the lawyer's affidavits and affirm that
what are big plans today? You know, I'm gonna go to Home Depot.
Authorize the
What
lawyers
kind of sales they got going on?
whether or not they would execute an affidavit. It could be 2 sentences. we reached a final decision unanimously to acquit Ms. Reed of counts 1 and 3. Your Honor doesn't have to accept 4 out of 12 or 5 out of 12. Your Honor has a lot of discretion in terms of how to get to the bottom line, which is what is the truth here. Your Honor could schedule a hearing and have the 4 jurors in. They would remain anonymous. We would even waive public trial. I'm not sure if legally you would, but to keep this private and keep this confidential, because we don't want the jurors to, risk identity. Your Honor could do it in any number of ways. We have responsible court officers that can meet 4 jurors. Anywhere Your Honor selects, we have responsible lawyers and responsible prosecutors. This doesn't have to be an event that challenges the jurors' anonymity. I guess what I'm saying is that we're asking the court not through closing the door to this new evidence and really adopting a fiction that the impasse was on all 3 counts when we now know that there's strong corroborated, trustworthy evidence that is not, to establish a procedure consistent with McCollum, consistent with Sanaif, consistent with the Supreme Court decision in Renner, and take those cases where jurors do come in after the fact, when there's credible, responsible evidence that they were either biased or that they had some extrinsic evidence, whether from the internet or from improper contact with a third party, and help us investigate this. I don't believe that if the Norfolk DA was convinced from that process, and it could be 4 jurors, it could be 12, but if I tell the court, we made a final decision, we never went back, like the Bluford case, or to re-examine it. It was not an intermediate decision, it was a final decision.
Can you blow bubbles at the same time? Walk, chew gum, blow bubbles, be on the phone.
I am hopeful that the prosecution would join with us in not seeking a new trial. If they were convinced by these jurors.
You should be on America's Got Talent.
Under oath to what they've not yet been convinced by, which is defense counsel. This was a hard-fought case, and I'm not being critical
I need
of the DA. But I've done this.
Do all the things.
And I believe in our system of justice. People say it's not perfect, but it's the best that the world has. This to me is hallowed ground in a courthouse named after someone who was a friend who I deeply respected. And I want the prosecutor to get the facts in the best way we can at this point in the case, which is through Your Honor. Order a hearing, Judge. Don't make Ms. Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office that tried her once and failed to persuade the jury she was guilty. They've not given a single case where facts like this have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration.
Sam Rand's gonna win, so.
We were silent when we shouldn't be, but she was acquitted. They've got the.
Just be prepared, Randy, on that day.
There was a verdict slip, nobody knows when it was
We
written.
are enemies.
Bluford, but there was clearly further jury deliberation after a juror told the judge that we had reached a decision on 2 counts. I'm convinced, perhaps, through many years of doing this, that acquittals count. And if she was acquitted, nobody wants her re-prosecuted on the counts.
See, they're using the double jeopardy
Forms important,
thing.
Procedures important, but what's more important is substance. What's more important is to find out whether that jury, in fact, voted to acquit and it was a final vote. And then I hope there's no dispute. I hope Mr. Lally will stand up in front of you and join me and asking that those two charges not be re-prosecuted. So
Oh,
let me
Lord, y'all. I got
switch
the police
from
commissioner in Detroit following me on
its
X.
implications to manifest necessity.
Uh-oh.
In this case, we have explicit guidelines.
What did I
that
do?
have been set out by the Supreme Judicial
Look at her.
Court
She's so smug.
that look to whether or not there was manifest necessity for the declaration.
He's running for mayor.
of mistrial. Manifest is a word that says to show clearly. And
Who is this guy?
whether the mistrial order was
Ricardo
avoidable,
Moore.
whether there were any viable
Don't think I won't look
options,
you up and figure out
whether
where your
the
money
court
comes from.
essentially had no choice, no options. But here at minimum, with 4 or 5 jurors
Oh, he's
saying,
putting all kinds of Bible verses in.
"We
Ooh,
believe
liar, liar,
the
pants on
innocent,
fire.
we
Uh-oh.
believe there was a vote." There's no evidence from those
Putting all kinds of Bible verses on here. You better back that up, buddy.
Counts 1 and 3.
God first. Uh-oh.
That would have
Uh-oh.
rationalized and justified the order of mistrial. The note, as I said, was believed to be unambiguous by the prosecutor, but in truth was ambiguous. It led to 1 or 2 constructions.
Look,
So
people.
this is really becomes a burden of proof issue. You know, who bears the burden when there was
It's
an
132.
understanding by the court that the note reflected an impasse encompassing all charges, when we now know there was a rational alternative explanation for the note, a logical one, which is we were addressing only the charges in count 2, the multiple charges, the multiple decisions within the manslaughter count. Here's where the court helps us. The Supreme Court in Arizona v. Washington placed a heavy burden on the government and prosecutor to justify a mistrial. The SJC has issued multiple opinions. I'll read just a couple, because I think the burden of proof issue is central, Judge. Commonwealth versus Stewart.
Come on,
goes back
man.
to 1985.
Come on,
It's one of
man.
the central decisions that started formulating the jurisprudence around double jeopardy and manifest necessity.
See, they're using double jeopardy in this.
The prosecutor must shoulder the burden of justifying the mistrial if he is to avoid the double
I don't know what he's
jeopardy
talking
law.
about.
His burden is a heavy one, citing to Arizona v. Washington. Cruz v. Commonwealth, SJC 2012.
Dude, this is crazy.
The heavy burden of proving that a mistrial was due to manifest necessity lies with the Commonwealth. Commonwealth versus Nicole, 452 Mass. 816, 2008. The Commonwealth is unable to satisfy its heavy burden of proving that there was manifest necessity for declaring a mistrial, and the Commonwealth is therefore barred by the principles
I'm
of
still
double
waiting.
jeopardy from retrial.
Yara said they're still.
I have a copy of the Nickel decision because it's the one that was not referenced yet for your Honor's consideration. Nickel was an interesting case. It was a driving case, jury of 6. There was belief that one of the jurors should not be sitting because he knew a witness, if I'm recalling the facts correctly. And everybody considered it and thought there was no procedure to allow a trial to continue with a jury of 5. The defense counsel thought that, and the court thought that, and the court therefore declared a mistrial. Afterward, everybody discovered that this is in fact a rule of criminal procedure, and that defendants could waive a jury of 6 just like they could waive a jury of 12. And the court determined, as I just read, that there was no manifest necessity because there was a viable option to the declaration of a mistrial, that being the court could have asked the defendant whether or not they would agree to a jury of 6, but they didn't recognize it at the time. And then the court had a decision. Are we going to blame the defendant, make them go to trial a second time in the face of double jeopardy's manifest necessity requirement, Or are we going to put the burden on the prosecutor to have advised us of that rule? This case is similar, Judge, because what you weren't advised of is Mass Rule 27B. See, everybody focused on Roth.
Okay, they're waiting on the judge.
Juvenile and Bluford, where all of them were single counts with lesser includeds. In the Roth case, the SJC decided that it prohibited judges like yourselves from inquiring into the vote. You couldn't ask the jury, well, if you have
they're in the courtroom right now. They're waiting for the judge. It's my last update that I have.
But this is different because we had 3 counts, not 1. And Rule 27B that you were not advised of, and we contend, of course, the burden was on the table of the side that wants to re-prosecute her, says as follows. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded.
Oh, I just need her to say, this is
rule
over,
also
you've got
provides
time
that the
served.
court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on. That rule, had it been brought to the court's view,
I know.
provided a viable option to a declaration of a mistrial. It would have justified the courts, it would have required the court, as well as justified, to ask the jury whether or not it was an impasse on all counts, or rather than just one. So the Supreme Court not only puts the heavy burden on the prosecutor, but provides a set of guidelines which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them 2 principles guiding our review of manifest necessity. One is counsel must have been given, and the word must implies it as a mandatory, as an imperative. Quote, counsel must have been given full opportunity to be heard, and I'll address that second. And quote, the trial judge must have given careful consideration to alternatives to a mistrial. These are the legal.
Oh, okay. Sorry.
We contend.
Here we go, guys. Look at this. Who's this dude? All right, look at this. Okay, there's Brett Foreman, that garbage man. There's Jeff. You see Jeff. There's the sister, the mom, the dad, their sister's husband. Jeff was sitting next to her dad. Now he's sitting over here. Why is Jeff there? Why is this Brett Foreman guy so creepy? He didn't even know her that well. Why are these guys all smiles? What the heck's their deal? Ugh. I know, Ryan. I know. That's what I'm saying. I don't even think these are the same prosecutors. That's not the same guy that was doing the case. That is not the same. Neither one of these prosecutors are the same. Where's the other that's not the same prosecutor, right? The co-counsel that was such a turd. Yeah, these are different dudes. What are you laughing about? There's a guy's life on the line here. What are y'all smiling about? Y'all, I got this new computer and I'm still trying to get used to it. Y'all are going to laugh at me, but I do not know how to make, because it's a Mac. I don't know how to make the whole screen be on the computer. Is it DeGrazia? That's him? Okay. Maybe because I just saw the back of him the whole time. So I can't, my computer, my screen is only on half of my screen. I don't know how to expand it to the whole screen yet. But I've not used, I don't use Apple products, so I don't know how to do it. So I need to learn. Oh my gosh, Kirsten. I swear that doesn't, I thought maybe I'm just watching so many trials I don't remember. I swear I thought he was that guy's chubby, but I thought he was chubbier and had lighter color hair. I just don't like their face. I don't like their facial expressions. I don't like that Jeff is there. You know what? Jeff is probably there because he needs to see for himself what his future is going to hold, because y'all, his butt is on the line too, if you think about it. Well, there's two creeps sitting right next to each other. I mean, you got Brett Foreman and you got Jeff. How weird is that? Yeah, that guy's definitely creepy. Super weird. I know. That guy, like, first of all, he's not agile enough to have done this. I don't think he did it because he's just not. I mean, come on, look at him. Come on, man. Look at that guy. I have a feeling, you know what, Jessica? I think I was literally just talking about that this morning. I have a feeling Jeff Herbstman, that is what's going to happen, because look at the way he's sitting, just the way he was sitting earlier. I have a weird feeling that that's what's going to happen, that he's going to do something to himself, because he's not going to be able to hold this secret any longer. And the synagogue and the family is not going to keep covering for him much longer. They got to know, you guys. In their heart of hearts, they got to know. Yeah. So I think, yeah, look at him. Look how he's sitting. Look at that head down. He's worried. He's very, very, very worried. So if that happens, God forbid, I think that will seal it. Yeah. Yeah, David, God forbid if that happens. I think that will seal it, but I feel like it's going to eat him alive. But the way he's sitting, his posture, he's got his head down. I'm shocked that he's there, but I know why he is. He's there because he wants to see what his fate holds. Yeah. he's there because he's got to see for himself if he's next. Oh my gosh. I'm trying to stay positive, y'all. What in the world is this judge doing? I mean, of course, David, he definitely feels like he's been kind of, I guess, kind of cleared because, right, yeah, I think he's feels pretty good about the position he was in. But if this case gets dismissed, he's not going to feel that comfortable anymore. I just can't see how he's felt this comfortable to keep going to the synagogue. I mean, you got to keep up appearances though, right? You can't just like stop going to your synagogue. You can't stop everything that you were doing, or else that will make you look guilty. But I mean, I don't know how confessing didn't make you look guilty. I don't know. He has to live with that. Right. Yeah, that would look more suspicious if he stopped. I mean, it could look more suspicious, or it could look like he just can't handle the grief, you know? But it could go either way. But, you know, the way he's acting in the courtroom right now is really weird. I mean, he's being very like all in a shell, like his posture's weird. Everything's just weird. It will be very difficult to convict him because unless they find that evidence, which they're not looking for. Yeah, you know, that's what's so crazy, LaDonna, is usually people like that, that's what they do. They want to be very close to the case because they want to see where they stand. And that's why I think he's there, because I don't think I have seen him. Actually, I know he hasn't been there other than when he testified. He hasn't been there with the family like that. I mean, I know pretty much what's been going on in the courtroom, and he has not been there. So for him to be there today is very telling. Right. And they go, you know, they always they go to the crowd, they're at the crowd, they go to the funeral, like he was at the funeral, of course. It's just very odd. Okay. The judge is there finally. Holy moly. Look at him. There's Tiara in the back. Gloves are off today, you guys, just so you know. Defense is not playing around today. Yeah, his body language is very telling, Ryan. I don't know. I didn't even get to see because they panned the camera over to her so quickly. I guess she didn't like her lunch.
Oh, I'm sorry? Oh, it's not during trial now. Okay, don't film the defendant as he's coming out from the back, please.
They gonna see him.
Great.
They gonna see him in green anyway.
I don't know.
I mean, it doesn't matter now.
That's what I told my deputy. I think she prefers not to be in person.
I know you guys. Lord, please, 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 please. Set Michael free. He doesn't deserve this. He deserves to be free. This trial has been so unfair. Lord, we are all praying. Please do the right thing, Lord. Please have them do the right thing. I had to take a lot of medication to sleep last night, Lord, and I know a lot of us did not get sleep. Tiara did not get sleep. A lot of people did not sleep. This has been very nerve-wracking. Lord, I prayed last night. I know you'll do the right thing, Lord.
Calling case number
Okay, Lord. Please, 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 please.
24-000-535, People versus
Please,
Michael
Lord.
Jackson Bolanos. Appearances, please.
Good afternoon, Your Honor. John Boyd Hall for the people.
Dominic DeGrazia on behalf of the people.
Brian Brown on behalf of Mr. Jackson Bolanos.
Good afternoon, Judge. Mr. Jackson Bolanos, here tonight.
And I know for the record, Mr. Jackson Bolanos is present as our counsel. He may be seated. So we have a motion to take care of first, and then sentencing on the charge he was found guilty of. I did review the defense's motion to dismiss based on double jeopardy grounds and the case of Yeager versus United States. And the defense is saying that that precludes retrial of both the felony murder charge and the home invasion first degree charge. The people, although disagreeing with the findings or the rulings in Yeager and plan to appeal according to their brief, the actual findings in Yeager, the holdings in Yeager, and arguing that it's bad law, concede that the court has to follow the precedent set in Yeager in not in granting the motion to dismiss with regard to felony murder charge, if I'm paraphrasing correctly, but not as to the home invasion first degree. So I guess I'd like to have the people address that, and then I can have a response from the defense.
Certainly, Your Honor. Court has accurately indicated what our position is that as to the felony murder charge, the Yeager versus United States opinion basically says that the jury has made an ultimate finding of fact in this particular case. They found based on the not guilty verdict as premeditated murder and the lesser second degree murder counts. By finding that, they found that the defendant did not commit a malicious murder in the case. That finding in itself precludes a retrial on the felony murder charge, which, you know, as this court well knows, is that basically what felony murder is a malicious murder committed during the commission of a felony. So we do concede that what Yeager holds would require this court to dismiss that particular charge, the felony murder charge. We do object to that because we do intend to seek an appeal to the Supreme Court, and we seek we'll be going through the state courts on our way to the U.S. As to the other charge, the home invasion charge, also relying on Yeager versus the United States, we do not believe that there is a similar or a common ultimate finding of fact between the acquittal in this particular case, the murder, and the home invasion. The standards that Yeager sets out is whether a rational jury could have grounded its verdict on any issue other than what the defendant seeks to foreclose, which being the malicious murder in this particular case. I think it is rational for a jury to believe, based on the facts that are presented at this case, the evidence that was presented during the trial, that it is rational that the defendant did go into the house, did go into Ms. Wall's house, without finding also that he was the person that committed the murder. As the court is aware, why Mr. Bolanos was in this area, why he was even in Lafayette Park at this time, was he was committing a series of opportunistic larcenies.
Exactly, Ryan.
Throughout the city, throughout the area. And that's what brought him to Lafayette Park. So it is rational for a jury to believe that he continued with that the seeking of opportunistic larcenies in the area by finding either before the murder or after the murder, finding the house, Ms. Wall's residence, available and open, and then taking advantage of that and went into the location seeking to do another larceny. So I think a rational, based on the facts that were presented in this case, even if the jury was to find that the defendant did not commit this murder, there is still evidence for a rational jury to believe that he did commit the home invasion.
No, there's not. No, there's not.
Yes.
Come on, Brian.
They concede the felony murder. We don't have to really address that issue. But as far as the home invasion, quoting Yeager, the issue preclusion portion of double jeopardy is a different analysis, where you don't necessarily look at the elements of the crime of which an individual seeks to have that issue precluded or that particular offense precluded. But you would look at the arguments that were addressed at trial and the evidence that was presented at trial. At trial, their theory was that Mr. Jackson Bolanos went inside of this particular house to commit an assault. That was the predicate under home invasion 1, that Mr. Jackson Bolanos went into this particular residence to commit an assault. The jury found that he did not commit any type of assault. He was acquitted of first-degree premeditated murder and the lesser included second-degree murder. So under their particular theory, that issue has already been addressed. So the inquiry is whether or not in the second trial, a jury can conclude, even by an inference, that Mr. Jackson Bolanos could be convicted of home invasion first degree without being convicted of a murder, which they cannot. Because, like I stated, the predicate for their home invasion was an assault. So how can, at a second trial, the jury would be in a position to find that Mr. Jackson Bolanos committed home invasion first degree if he didn't commit any type of assault on her? So they basically want another bite at the apple, and they want to change their theory and say that, oh, okay, our new theory is that he didn't go in to commit the murder or an assault, but he peeked in there while she was present before the murder or after the murder, which no evidence substantiates that theory at all. They're just throwing things at the wall, hoping something sticks and changing their theory. They've already unsuccessfully argued their theory, and for them to get another bite at the apple, Judge, that'll be against precedence.
Thank you. Come on,
So,
Brian.
Judge, saying all of that, we feel that home invasion first degree was already litigated. That issue is precluded from any subsequent trial, and both home invasion first degree and felony murder needs to be precluded. And I wanted to address just their second theory. Their second theory was, even if it's not logical, because it's not, even if it's not logical that a home invasion first degree could be recharged based upon the lack of an assault because he was acquitted on that, we could then try to charge him with home invasion second degree. Basically, they're trying to say that, her body was outside. He didn't do the assault, but he went inside of her apartment after she was already committed. After all of this blood was located inside of the apartment, somehow he went in there and triggered the motion with no footprints near the door, no footprints in the apartment, but somehow he must have or could have went inside of this apartment after she was already murdered. And that's just preposterous. That's just another unsubstantiated theory with no evidence to support that. And they've already had their opportunity, and they unsuccessfully argued that under the predicate that they asked this court for. They asked this court to instruct the jury to decide whether or not he would be guilty of home invasion first degree under an assault, not a larceny, not a larceny. So now they want to say that, oh, it's reasonable for a jury to decide that, oh, he was doing opportunistic larcenies throughout the city. So it's reasonable for a jury to conclude that, oh, he was still in that opportunistic mindset when he walked into the apartment. No, they didn't argue this at trial. Their theory was he went in there to do an assault, not a larceny. And we questioned that while we were preparing the jury instructions.
Look at that prosecutor.
That's what you want, right?
And him.
That's what they wanted. That's what
He
they
was shaking
got.
his head.
And they did it unsuccessfully. They don't get another chance, Judge. Thank you.
Go, Brian!
Reply?
You better not. You better not.
My memory of what our theory was. Is
Your
that
memory, you weren't there.
Charged as felony murder, with the underlying being a larceny. So the reason
I
for
know.
going into this house in the first place
Año.
was to commit a larceny, not to go into this house thinking that he was going to assault Miss Wall if he happened to find her. That was, I believe, our theory. That's how we charged it. The jury is not bound by what our theories are. They're bound by what the evidence is.
Año. You charge him with premeditated murder.
Would it be rational for them, based on the evidence that was presented, for them to find a home invasion even without finding that he committed murder? Our position is yes.
Año.
Just a quick reply. He states his memory. He didn't participate in this trial. So
That's
his
right.
memory
Thank
may
you.
Not be at where it should be in order to, I guess, recite what the elements were and what the jury instructions were.
I've got the instructions.
Okay.
Right
Thank
here.
you.
Okay.
Thank you.
I just had my law clerk print them off for me.
Thank
These
you.
are the ones I read during the trial. So in a way, he is correct, because under the felony murder charge, they had the crime of larceny and or home invasion.
But he was acquitted for that.
Understand?
Okay.
But so he's correct that under the felony murder, their theory was larceny and or home invasion.
Bitch, please.
But under the home invasion,
Are you about to make me
we've
say
had
some shit?
discussions about this before the trial began, and in the information itself, count 3 home invasion alleges that the defendant did break and enter or did enter without permission a dwelling located at Joliet Place in Detroit, and while entering, present in, or exiting from, did commit an assault. And while entering, present in, or exiting the dwelling, Samantha Woll was present, legally present there.
Thank you.
So the only theory under the home invasion charge in the information was committing an assault.
Thank you.
Not the theft theory. And in jury instructions that were given to the jury on count 3, the second element was that the defendant entered, was present, that when the defendant entered, was present in, or was leaving the dwelling, he committed the offense of assault and battery.
Thank you.
And nowhere in the instruction on home invasion first degree did we talk about larceny.
Thank you.
And that was not in the people's information either, under the theory for home invasion first degree. It would seem that the underlying theory of assault would also be barred, and that was not, and there was no mention of the home invasion of larceny under the home invasion.
Get it right, lady. Get
both
it
in
right.
the, information and in the elements that were given to the jury. So I believe, as Jaeger still appears to be good law at this time, the court is also precluded from retrying the home invasion first degree because it was based on the assault and battery theory, and obviously assault and battery would carry on with the ultimate crime of felony murder and the attack that happened to Miss Wall. So I believe that based on the theories presented by the people in the information and in the instructions as were agreed by the people in defense, home invasion first degree would be precluded as well. But I do want to address the Jaeger opinion. I did pore over this opinion quite thoroughly, and I do agree with the people that it is a poor decision, and presumes that when a jury makes an inconsistent finding of being hung on one count, but finding not guilty on the other count, that it must be that the not guilty applies to both. And after listening to this trial and listening to all of the emphasis that was put on felony murder, and basically the people barely mentioned first degree premeditated murder in their openings, closings, or anywhere throughout this trial. The main focus, and I believe the prosecutor even said, the main focus of this trial is the felony murder.
You still a
And
bitch.
there were still jurors who were voting for guilty on felony murder, and they were hung as to that count and as to the home invasion first degree. I don't believe this jury had any idea that when they found him not guilty on the
It don't dang matter. He's not
first-degree
guilty.
murder, that they were precluding a retrial on the felony murder. Inconsistencies. The jury can't
This
be
bitch.
charged with knowing that
This.
the realizing the elements of second-degree murder are essential for the elements of felony murder. They're not legal scholars.
Look,
They're
look,
looking at
lady.
this as separate.
You're
types
not
of
either.
charges. And I think that Judges Scalia and Alito were right when they were saying that under all of the prior rulings prior to Yeager, that a jeopardy continues until a hung jury is able to deliberate and return a verdict on all counts. But I am bound by Yeager.
That's
And I
right.
can't
You bound by it,
precedent
bitch.
That's been set by the U.S. Supreme Court.
That's
So
right.
I am going to have to dismiss.
Thank
as to
you.
both
Thank
felony murder
you.
and the home invasion degree.
Keep your opinions to yourself.
And the people are going to appeal this decision and see what happens from there. We are today here, though, and he was acquitted on the first degree premeditated murder, so then that leaves the count 4, lying to a peace officer. And
That's
we
a
are here today
misdemeanor,
focusing
bitch.
on that charge for which the jury did find the defendant guilty.
And it's time served, bitch. Time served.
And have all parties had an opportunity to review the pre-sentence investigation report?
Yes, sir.
Yes.
Are there any corrections, deletions, or additions to the body of the report?
Yes, to the body of the report, we would object to mention of all acquitted conduct for Mr. Jackson Bolanos. They go through a lengthy recitation of what the investigation consisted of, what the police did.
Well, Brian looks good today, y'all. His hair looks good.
With murder, and we would like all of that stricken from
He got his hair
pre-sentence
did.
investigation report. I believe the only information that should be contained in the pre-sentence investigation.
Yes, David. God bless.
Any
God bless.
information pertaining to his conviction of lying to the police.
Yeah.
I'm sorry, in regarding larceny from a vehicle, not lying to the police in regards to touching her body.
Your Honor, this exact argument was raised in People v. Stokes. That's a Michigan Court of
Shut
Appeals
up.
case at 333 Mishap 304. The defendant in that case objected to information about acquitted conduct being included in the pre-sentencing report. Michigan Court of Appeals stated that it was not an error for the judge to be aware of that information as long as the court did not use acquitted conduct as the basis for her sentence. And I don't believe I would not ask the court to use acquitted conduct, and I don't believe the court would. So following People v. Stokes, there's no merit to this argument.
And I believe the court is very aware of the facts and circumstances of the case, seeing that the court was present for a 5-week trial. So I don't believe that the information contained in the pre-sentence investigation report is necessary to inform or refresh the court's memory of what the allegations or the investigation was.
Well, you're
Sorry,
talking about
sorry,
the
y'all.
description
I'm
of
so
the
sorry
offense
for your
narrative,
loss.
And that is taken directly from the police department's investigator's report. And I've never stricken any parts of that investigator's report. That is how they came about to this.
He
whole
has
thing.
to be let
It is
go.
noted in here at the end what happened with the various counts, and so anyone reading this will realize that what had happened. I do note on page 5 of the evaluation and plan, which is the end of that narrative of the description of the offense, that it didn't actually say what happened to count 4, and so I added the sentence at the end of the last paragraph, right before it says consecutive sentences. The defendant was found guilty by jury of count 4, lying to a police officer.
Okay. It's a misdemeanor.
Because they didn't say what the result of that charge was.
It's a misdemeanor. Say something, Perna. Say something.
And Judge, just if we could add just the language that he was convicted of lying to a police officer and regarding an investigation about larceny from a vehicle. So I think there might be some type of confusion. I know the court may not be confused, but there might be some kind of confusion of what he was convicted of about lying to the police about. I think there might be some confusion that he was convicted for lying about the knowledge of Samantha Woll, which is
Well, I could say peace officer for a felony punishable by 4 years or more.
What? That's a felony, not a misdemeanor.
That's
Anya!
actually how it's listed. That's the name of the crime.
No,
So
Anya. What are you looking at, woman? No. Why are you trying to do this?
are there any other corrections, deletions, or additions being requested at this time to the body of the report?
None on behalf of the people.
not to the body, just some guideline issues.
Mr. Jackson Bolanos, is there, you went over the report with your attorneys?
Yes,
All the information about yourself is correct?
yes.
Okay. I also want to note under the prior offenses, there seems to be some discrepancy from the 2013, the adult history 1 of 1, or 1 of 3, I'm sorry, on page 8 of the report at the bottom, it says 8. Adult history offense 1 of 3.
Yes, sir.
It says that the defendant was resentenced to a prison term there was a narrative further in there, but it looks like his HIDA was revoked and he was sentenced to a prison term. But then there's also something in our Odyssey system indicating that it was closed under HIDA. So there's an inconsistency in there. And if
I would say Haida. He was closed under Haida.
well, no, but he was resentenced to a period of prison term and he served the full 5 years. And so that's not legally possible that you could do that. And so that is being brought to Judge Deborah Thomas's attention. She was the judge on the case for her to make.
What is she
corrections to the record that
doing?
need to be corrected because it is inconsistent.
See you later,
To
LaDonna.
say that HIDA was revoked, and he was sentenced to prison for 18 months to 5 years.
Yeah, and he spent the whole 5
served
years.
the full time and never was discharged on parole. He served till the discharge date, and then somehow it said closed under HIDA. So it's not legally possible to do that.
Okay.
And so Judge Deborah Thomas we pulled that file. She'll have to take a look at that to look
What
at
the
that
heck?
inconsistency and make any corrections she may need to make to the court file. I just wanted to note that for the record that we were looking at that. Noted that.
I saw that too.
Anything further with regard to changes, corrections, deletions, other than the guidelines?
From my perspective, no.
And with regard to the guidelines, I know I received an email from defense arguing that OV-19 should not be scored at 10 points based on a rather recent Michigan Court of Appeals or Michigan Supreme Court opinion, which there was another dissent. Did you wish to address OV-19?
Yes, I believe it is scored properly. I've had a chance to look at the case that defense counsel sent this morning. That case basically stands for the proposition that there must be something more than a suspect's denial of the accusations. And this was in the context of a one-off statement in the course of a search warrant that was executed at this Mr. DeWeird's home. What we have here is very different. And I would point to the cases that are cited in this DeWeird case, People v. Barbie. That's
you
an
spell
example.
that?
Sorry, what?
Spell the name for the court reporter, please.
BARBEE. That's at 470 Mish 283. In that case, suspect provided a false name to police, and the Supreme Court has upheld that as a valid a valid scoring of OV-19. The central question for determining whether there has been a violation of OV-19 is, did the ultimate effect of what the actions of the defendant were meant to conceal his guilt in the manner that was being investigated, or the administration of justice. And what we have here is the defendant's repeated lies, knowing that he was being investigated for larceny from a person. When he testified, the defendant testified that the reason he was lying to the police was because he was afraid of being arrested and charged with a crime because of the potential punishment. So this goes far more than simply a one-off statement during the execution of a search warrant. This was a deliberate pattern of misdirection, concealment, and deception that the defendant engaged in knowingly and willingly because he was afraid of the consequences of being honest. So when you look at the cases where the courts have upheld the scoring of 10 points for OV-19, lying to the police to hinder investigation, destroying evidence, providing a false alibi, providing a false name, all of those types of behaviors have been upheld as valid scoring of OV-19. And in this case, the defendant is convicted of lying to a police officer, which in and of itself would seem to qualify under OV-19. But if we're looking for something more, it's the deliberate pattern of deception, knowing and purposefully to avoid arrest by the police. So I believe it should be scored at 19 points.
And that analysis is just totally factually incorrect. The D-word case stated that a lack of culpability does not indicate that OV-19 should be scored. It has to be something more. Barbary, it was an attempt to conceal his identity or conceal evidence. Other cases, such as if an individual flees from the police or hides from the police. And the court stated, People v. Dixon stated that if you use a lack of culpability, basically not admitting to the allegations right there, then OV-19 is bound. Then you'll be able to charge somebody under OV-19 if they remain silent. You'll be able to charge somebody under OV-19 if they decide to go to trial despite having overwhelming evidence to the contrary of their innocence. You would be able to charge them under a plethora of different circumstances where OV-19 has not been or supposed to be used under those circumstances. An individual has a presumption of innocence. So if the police ask you, did you do this crime? And then you say no, that does not impede their investigation any more than if you remain silent per case law. That's what the court stated. So if he were to remain silent, or if he would have said what he said as far as that's not me, it has no other impact or no more of a detrimental impact on their investigation at all. He didn't say, oh, I know who did it. It's John down the street. And then they went to investigate John down the street. Had that happened, then yeah, maybe OV-19 would have been applicable in this particular case. Or if he tried to come up with a false alibi and then the police had to expend resources to track down who he said he was with, like I was with my ex-girlfriend, and they had to go track her down, call her, interview her, just to find out that he lied. Under those circumstances, yes. But just him simply coming to the police station and saying, I did not do what you accused me of doing, Judge, clearly the case law says that OV-19 cannot be scored under these circumstances. So it's not valid.
Well, I think I'm bound by DeWeerd, and that's spelled D-E-W-E-E-R-D, and that is 511 Mish 979. That's a 2023 case that came out of the Supreme Court. Although there was a compelling dissent written by Justice Viviano and joined by Justice Zara. But that's...
Hey, Judge, this goes more than just a denial. He didn't just go to the police and say, oh, I didn't do it. He engaged in a deliberate pattern. He did give a false alibi. He did lie about the circumstance of what it did. All of these factors that are mentioned in DeWeird, where they're saying that,
What's false alibi?
Exactly.
he claimed he was at a gas station. He claimed he was at his aunt's house. He claimed he wasn't even there breaking into houses all night. The
He
police
wasn't
did have to
breaking into
run down
houses.
these different
He doesn't
leads
remember
and
the
check
facts.
these things out.
Hold on.
Breaking into houses. What is he talking about?
Cars.
Cars,
Yeah.
that's what I meant.
That's what he's talking about.
He's claiming he was doing other activities. He was in completely other places. He said he was, I was at my aunt's house. I was over here talking to a girlfriend. I was doing all these other things other than what he admitted that he was doing, which is lying to the police. So there's clear distinguishing here between DeWeird and the other cases that the court in DeWeird said were still valid uses of OV-19.
And his remembrance of the facts is flawed at best and disingenuous maybe at worst, or maybe it's flat out lies at worst. However, he never said he was at a girl. Sergeant Ford said, "Who are you talking to? We see you talking to somebody on the other side of the wall." He's like, "I don't remember. I don't know. I know somebody who stays in the King Hall. I don't know if I was talking to her." And then furthermore, and it was about an hour into the investigation that they even told him where or what day this happened at or where it happened at. He never had a false alibi and said, "I wasn't there." They asked him about a bag and he was like, "Oh, I might have, got it from a gas station." They didn't say, "Oh, on October 21st or October 22nd, you were seeing Kendrick's bag." They show him a picture of a bag walking downtown and say, "Oh, what's in this bag?" Like, if you can show me carrying a bag from Whole Foods and like, "Oh, I know you went to Whole Foods," I can't remember what day that was at. It could be on any day. Judge,
I was already ruling in your favor.
I'm sorry. I just wanted to. I know. I'm sorry. I apologize. It just.
OV-19 will be at 0.
Thank
Takes us to 0 for OVs down to level 1. Any other objections to the guidelines?
Yes, PRV1 is improperly scored at 25 points. I believe they're double scoring his previous conviction for juvenile. They already scored that under a high severity juvenile conviction, and then they in turn scored it under a high severity adult history, which there is no adult high severity convictions under Mr. Jackson Bolanos' record. So that should be scored at a 0.
No. The 2018 conviction, which is an adult offense number 2 of 3, he was charged with receiving, concealing stolen property as second offense. And that's what he pled guilty to. So that receiving,
Which is what? 7.5 years?
Yes,
Hi,
it goes up
welcome.
to a level D offense, which is a high severity felony.
But he is charged with a misdemeanor right now. This is a misdemeanor.
Do you contest that?
I contest, yes,
Yes.
absolutely.
All my guidelines.
Oh my gosh. Look at your Michigan law. The law says 93 days and a $500
And
fine.
I believe they dropped the habitual status, representing him on that case. He was in sentence under habitual status.
Yeah, hold on. Oh, it says in the history that he was, but let me look and see what it says in our court. What's the case number? Hold on.
I've never seen people work so hard to put someone in prison for something so minor. They ought to be ashamed of themselves. Lying to police? Are you serious right now? Are you dang serious right now? This is what you got. Oh my gosh.
Well, it says stolen property, receiving, concealing motor vehicle, second offense. In the records, I do not have the documents available to me.
So you shouldn't even be considering it. He served his time. It is done.
guideline book, it is listed as a level D, which is a high severity.
Hold on, let me pull it up.
Dude, shut up.
What's the
Man.
back code?
750-535 paren 8.
5358.
Yes.
Y'all are wrong. Y'all are so wrong for this. God don't like ugly, y'all. God don't like ugly.
Yeah, second or subsequent offense is a 10-year penalty, which would make it a level D. Which does make it a high severity. So OV or PRV 1 is correctly scored at 25 points. Any other objection to the scorings?
No other objections to the scoring. That would put his guidelines at 0 to 22.
That's correct. Under the G grid.
Yes.
I don't understand. I don't know what's going on. I don't understand this.
Do you concur?
Yes, sir.
They're taking into consideration
I
his
concur.
past.
People like to state before I impose sentence.
Yes, sir. When the court imposes sentence, I think there are a number of factors that I think the court should consider. I want to particularly talk about defendant's previous criminal history.
No, Anyo.
Because I think they're reflective and it's something the court should consider. 2011, the defendant was first adjudicated as a juvenile for robbery unarmed. He was convicted of that, or adjudicated for that, despite his testimony at court that he had never been convicted of a robbery crime, which is obviously false. But he was placed on probation in October of 2011. Within a short period of time, he had a violation of probation for picking up a retail fraud case. Within a few months, he was then committed, which is a elevated punishment within the juvenile justice system. So already, within 5 months of his first adjudication as a juvenile, he's already violated his probation.
He's a kid,
Ultimately, his
man.
probation is terminated. And in 2014, that's when he gets his first adult conviction in the
Hi, Law.
justice system for fleeing
Law
and
and order,
eluding
how
the
are
third
you?
degree. Again, he's given a break where he is placed on probation under HIDA status.
Look at
I
Jeff.
assume that he was supposed to complete some sort of boot camp program at the film facility, but obviously he failed, and he failed within a short period of time on that. His probation was revoked, his HIDA was revoked, and he was sentenced to prison. While he was in prison, he was adjudicated and found guilty of over 40 misconduct offenses while he was in prison, including possession of stolen property, threatening behavior, fighting, assault on a staff, sexual misconduct, 40 adjudications of guilt within that 4-year period of time. He is released from the Department of Corrections, and within 5 months, he has now been convicted of another felony for receiving and concealing stolen property, second offense this time, and he is again given a break where he receives 2 years probation and the 6
Welcome
months
to the
Underwood
channel,
County
Law and
Jail, and
Order.
that's after serving 4 years in prison and committing a new crime within 5 months of being released. After he is placed on probation in 2018, he again violates his probation, again repeatedly. And all that is to say, Your Honor, that the defendant, whenever he has been out in the community, he has committed more crimes. Even at the time of this alleged offense, and we'll get to this in his testimony, he was again engaging in criminal behavior, even though he was not under any sort of court supervision. Now, in terms of the offense that he was convicted of, I think it's important to note that lying to a police officer is not some victimless crime that is of no importance or that isn't serious. Lying to a police officer during a criminal investigation is how innocent people get convicted of crimes, because law enforcement,
That's right.
prosecutors,
You are
we are
so
relying
right.
on people to tell us the truth about
Jeff lied,
their activity.
supposedly.
And when people lie, that's how people get caught up in the system. And you
Mhm.
have the defendant here who lied repeatedly,
Mhm.
testified under oath that he was constantly lying or consistently lying throughout these
Mhm.
police interviews. And he's offering to tell the police about drug houses, about human trafficking, about auto theft rings.
Dude, he's just
He's
trying to get
eager
out.
tell the police information which obviously would have likely been false, but could have possibly resulted in some innocent person being arrested. So
How do
that
you
this
know?
is not some victimless crime. And there were probably many hours spent in the course of this investigation chasing down leads, chasing down the defendant's false alibis and other lies that he gave during his statement. So the police time was used. We were all in trial, contesting every single
It's going to be
point,
1 to
every
5
bit of
years,
evidence.
Ryan. That's what
And
they're
the
looking
defendant
at.
has a right to contest the evidence against him. But after all of that, he comes and he testifies and he essentially says, oh, yes, everything I told the police, that was a lie. And the evidence that the prosecution has put forward, that was accurate. That's the result of his consistent deception to the police, wasting time, forcing the police and law enforcement to do things that they otherwise wouldn't have done, but for the defendant's deliberate decision to lie to the police. Now, in the Stokes case that I cited earlier, the case is clear that
Yeah, that's what I'm
the
trying to
court
look up. I'm looking
may
up the
consider conduct that is
level
relevant to
thing.
these particular crimes, and the res gestae of the case of the crime itself, even though the court cannot consider acquitted conduct. So when we talk about the other facts and circumstances which were surrounding the defendant's reason he got into a police interview room and was lying to the police, first of all, the defendant admitted when he testified that he committed a larceny of a person, that he considered numerous larcenies for motor vehicles, that the defendant was part of a auto theft ring where he was sending photographs of cars to other people who may have stolen those cars, that the defendant was also scouting people, scouting cars so that he could later steal them. Those are all admissions he made when he testified.
Okay. That wasn't
he was
a lie.
also admitted when he testified that he broke into a number of cars that night, at least more than 5 cars. So we have really just a number of victims of his actions that night.
But he wasn't lying.
And that all is significant.
Gosh.
Why? Because it ruins the quality of life for the community around him. Now, the defendant, throughout his statement to the police, and also in his testimony, it was clear that he showed absolutely no remorse for breaking into all these cars, for committing all of these crimes, because for him, the important thing was that, the items that he was stealing had no value, that it was just some property. And I think it was telling when he testified on July 8th, there was some discussion during direct examination about, going into cars, breaking cars. And the defendant said, I'm not hurting anybody. I'm not bringing any ill will towards anyone. And that's at page 14, line 3. So it's clear that the defendant, when he's not lying to police officers, he's engaged in a criminal lifestyle where he goes around seeking opportunities to commit crimes, and he has no compunction or any sort of understanding in his head that he's doing something wrong. This is a person who was doing all this, according to his testimony, not because he needed money. He specifically rejected this. He specifically was going out there to commit crimes because he liked to commit crimes. He was out there for 4 hours walking around.
Oh, no. Oh, even the Detroit Fox News is tired of hearing your mouth. I know, Law and Order. It's so...
commit crimes because he liked to commit crimes. He was out there for
Didn't like
4
to commit
hours
crimes.
walking around it.
Ay, go. Okay, that's Tiara, just while we're waiting for this to come back.
There to commit crimes because he liked to commit crimes. He was out there for 4 hours walking around it.
I don't know what's going on. Yeah, it's not working by refreshing. I'm going to go in and go back out. Go out and
commit crimes because he liked to commit crimes. He was out there for 4 hours walking around it.
Nope, it's not working. It's frozen.
Of his actions that night. Because he needed money, he specifically rejected this. He specifically was going out there to commit crimes because he liked to commit crimes. He was out there for 4 hours walking around it.
Yeah, something's wrong with their feed. I know, they're sick of hearing his garbage. Oh my gosh. But he's saying stuff that makes no sense, you guys. It doesn't, like, he's talking about that. He's not even talking to things related to him lying to the police. It doesn't even, like, so I looked up what this class D thing they're charging, that she's doing with him. A level 4 in class D felony, but it's not a felony. This is a misdemeanor. So I don't understand what they're trying to say, but it's 1 to 5 years in prison and a $10,000 fine. They're talking about a severity level, but I guess they're counting it because he has a previous, so, but it's not a felony. I don't understand this D thing. I'm very, very confused.
Commit crimes because he liked
my
to
God.
commit crimes. He was out there for 4 hours walking around it. There to commit crimes. There to commit crimes because commit crimes because he liked to commit crimes. He was out there.
He didn't like to commit crimes, dude. Shut up. Okay, here we go.
Lewis, he didn't say that. He said that's not me in the picture. And he said that all of 20 minutes before he came clean? They didn't even get a chance to leave the room. They, in their mind, knew he was lying. He came clean and he was very honest and said, yeah, that's me. However, when he denied it at first, like I stated, they didn't give him any specifics of when this happened. They didn't say October 21st, October 22nd, you were in the area of Lafayette and wherever, or you in the area of Harbortown off of Jefferson. They never asked him pinpointed questions. They gave him a screenshot of somebody holding a bag and said, that's you. You were going into cars. They never confronted him with any type of evidence to suggest, like, oh, we saw you going into the car. And matters of fact, he introduced evidence that they didn't even have. He said, I was out there taking pictures of cars. They didn't have that information there. They didn't confront him with a picture of that Dodge Challenger with Coast Guard plates. He stated that. And after we found out in the trial, that was the honest statement that he made, that he gave to the police. Now, just like OV-19, if an individual denies culpability, surely he shouldn't go to prison for that. He's innocent until proven guilty. It has to be something more. Just like OV-19, it should be something more in order to rise to the level of sending him to prison. Just him initially denying culpability is not enough for a prison sentence. How many individuals lied to the police and they never charged? Through the pendency of my career, I've never heard, never represented an individual who's ever been charged with just simply lying to the police officer, unless it's something super material, such as maybe they filed a false police report, they hid their car down the street,
Yeah.
and then they said they got carjacked.
Yeah.
Then the police are going out looking for a carjacker, spending all these resources just to find out the person who made that report lied to them.
Yeah, Jeff.
Or in the case where they get on the stand and they commit perjury, like people did during this trial.
Yeah,
People
Jeff.
committed perjury during this trial. Are they going after them? No,
Nope.
but they want to act like they're so concerned about the truth. Their own witnesses, they knew they were lying. Are they going to charge them with perjury?
Right. Oh, Jeff
Absolutely
just
not.
perked up.
Because it's not
Look at Jeff.
justice for them. It's not
He just
blind.
looked up.
They look at him and they want to
Woo!
convict him, and they want to punish him for something he did not do. And then they want to get emotionally charged to bring up all of this stuff, his prison record. Where's that information at? What prison record? Was that in the PSI? Was that contained in the PSI? He successfully completed his probation in 2018. He's learned from his mistakes. The fact that he was down there, he stole some candy, not minimizing that. He was fighting for his life. If that doesn't change your life, if that doesn't light a bulb in your head or light a fire under you to change your life, I've had multiple conversations with Mr. Jackson Bolanos. I can guarantee he won't even jaywalk going forward.
Woo!
He won't even forget to blow his nose after sneezing. That's how straight on the path that Mr. Jackson Bolanos has to be, because he knows that when he walks out from this courtroom, they're going to be looking for anything and everything to try to charge him with anything. You didn't cross at the crosswalk. That's a ticket. Hopefully we find something on you. He knows exactly that. So he is not going to have any more run-ins at all with the legal system going forward. The probation that Michigan Department of Corrections recommends, and we recommend that also, he's going to complete that without a stain or a blemish. There's not going to be any type of violation, because he knows if he comes in on a violation, the prosecution is going to say, see, Judge, send him to prison.
See?
He's not going to give them the satisfaction.
Let's go.
He's not going to give them the opportunity. Not just that he doesn't want to give them the satisfaction, because he feels in his heart and he knows in his heart what's the right thing to do, and he's going to act accordingly. Through these 243 days, he's had a multitude of opportunities to reflect on what he did that particular night. Now, he takes responsibility for what he did that particular night. And he knew that those bad decisions has led him in a position right now where he is handcuffed in front of this court. Picture has been posted across the world, across the universe. There's people on Mars who have seen his picture. And initially, before this trial, has associated him with being a murderer. How does that feel? How would that feel, knowing that you did not murder somebody? You just in the wrong place at the wrong time. And then the world is accusing you. They say, oh, the suspected murderer or the murderer. Some news articles call him the murderer. Some call him the alleged. Some call him suspected. But nevertheless, they associated his name, his picture, with the death of Samantha Woll. Now, we feel very bad for what happened to her. But charging him should have never happened, because that's not justice. That's not justice to the family. That's not justice to the community. And that's certainly not justice to Mr. Jackson Bolanos. Just to get anybody, knowing that the evidence does not point at him. Judge, there was a recommendation from the Michigan Department of Corrections that Mr. Jackson Bolanos be sentenced to probation. Judge, we're asking you to follow that recommendation.
Do it.
We're asking for an 18-month term of probation, because, Judge, I'm sure you probably not had many cases or sentencing in lying to the police, because they don't charge that.
No.
The only reason they charged Mr. Jackson Bolanos was in an attempt to stain his character.
Yep.
So when he does take the stand, or at trial, he's a liar. He's a thief. He had to do it. Mr. Elsie, how many times did he say Mr. Jackson Bolanos is a murderer? I mean, a liar. Oh, he lied 40 times. He lied 44 times. Lie number 1, lie number 2, lie number 3. Yeah, he admitted he lied. He admitted he lied. He's not a murderer, but he also came clean. He also told them the truth. He also told them what happened. Like, yes, this me, I take full responsibility. So 243 days, already incarcerated, fighting for his life, that mental anguish, the depression, the anxiety that goes with those 243 days. Because he wasn't just sitting in a jail cell with his feet up. He wasn't on vacation.
Oh, he had to have his feet up, y'all. They roaches.
Like that type of mental anguish to be charged with something that you didn't do, Judge.
You wasn't
I think
leisurely
it's
holding
more
his
than
feet up,
enough
though.
to ensure that going forward, that Mr. Jackson Bolanos will be a successful candidate, Judge. And considering the crime in his guidelines, Judge, we ask for a term of probation without the tether, because we believe that Mr. Jackson Bolanos is not a flight risk. He was arrested twice. The first time he was arrested, he never tried to flee, Judge. So there's no particular reason why he would flee. And he understands if he does try to flee or violate probation, he would be throwing himself in front of the court, and he knows where he would be going if that were to happen.
Mr. Jackson Bolanos, anything further you'd like to state on your own behalf?
Just that October before, it would be good in the community. Planning to go to school, I still have my job, so I'm working currently. Not right now, but when I'm out, yeah, I don't.
You need to see.
Don't be a witch.
This is a difficult case. We started with some very, very serious charges. And while it seems like this is not a serious charge, when you add the habitual fourth offense to it, raises it to a maximum penalty of 15 years.
What?
And what I have to look at is not just the circumstances of the offense, but also the offender. And habitual fourth raises this up into a straddle cell, 0 to 22 months guidelines, and the 22 months would indicate prison. And although it is a straddle cell, I could choose to give him jail time or just straight up probation. But I also have to look at the number of times that the defendant lied. And I have to say, if lying was an Olympic sport, you would get the gold medal, sir, because you told lie after lie after lie throughout those interviews, interrogations, and even a few on the stand.
What?
And the number of lies does factor into this. Also, the fact that there were prior failures to comply with community supervision, both with an unarmed robbery when he was a juvenile, and also for the fleeing looting. And not only was he removed from the Haida prison sentence at the Thumb almost immediately, but was given a sentence of 18 months to 5 years and served out the entire term and never actually achieved parole because there had to have been numerous misconducts that.
What are you talking about? That doesn't even say that.
DeGrazia had looked up, but were not included in this report. But it's obvious there were numerous misconducts for him to serve out his entire time.
What are you talking about?
Parole.
You're just assuming that. You know what assuming does.
The other factor I'm looking at is nothing to do with acquitted conduct or the charges that had to be dismissed pursuant to that case, but also to admitted other crimes that he admitted to on the stand that will never get charged. The breaking and entering into those cars, and taking pictures of cars to send to people to help them steal cars. That's all additional criminal activity. And apparently Mr. Jackson Bolanos, at the time of this offense, had not learned his lesson from all of his prior dealings with the judicial system.
Oh my gosh.
The prison system.
You can't charge him for
and
that
was still
now.
engaging in theft crimes on the night that this happened. And that's what put him in this place to begin with, and ended up having him charged with the
Oh my
more
gosh.
serious crimes.
She's a
So
witch.
it is the sentence of this court that Mr. Jackson Bolanos be sentenced to a period of incarceration of 18 months to 15 years in the Michigan Department of Corrections.
Oh my God!
243 days credit for time served. He must pay $68 state costs, crime victim assessment fee of $130, no probation. Court costs of $1,300, which is the amount this court has estimated is the average cost of a case coming through this courthouse. It's my duty, sir, to advise you of the right to seek appellate review of your conviction and sentence. If you're unable to afford an attorney, one will be appointed for you. They'll be given transcripts needed to prepare your motions or an appeal. If you wish to seek an appeal, you have to sign and date your appellate rights paperwork and mail it to the clerk of this court within 42 days of today's date. Your client's already initialed the form?
Yes.
Okay, we will give him a photocopy to take with him.
And Judge, just for the record, you made a reference to my client lying on the stand. Like, that's unsubstantiated that he lied on the stand. That wasn't even alleged that Mr. Jackson Bolanos lied on the stand. That this court made reference to lying on the stand. And just for the record, Judge, he successfully completed his last probation he was on in 2018. So he demonstrated to the court that he does have what it takes to be successful on community supervision. If you're going back from 2013 when he's 19 years old, I mean, this is 11 years ago at his last probation that he didn't successfully complete it. 2018 was his most recent probation, and he successfully completed that probation, and they closed him out.
Sir, I've heard you out. He may have completed that one, but then he was out committing theft crimes the night of this event.
Okay, but
Judge, admittedly.
Okay, but Judge,
and he's never going to face charges on that.
Okay, so that's uncharged conduct, and Judge, if they wanted to charge him on it, they could have charged him on that. But in this building, Judge, we got to be honest with ourselves. How many individuals get sentenced to prison for lying to the police, especially if they're not being charged with any type of larceny? That just doesn't happen.
How many of those people are habitual fourth offenders?
Oh my God!
That's my sentence. You can take it to the Court of Appeals.
Oh, will.
Defendants remanded to the custody of the Michigan Department of Corrections. I believe that dismissal has to be with prejudice, correct, pursuant to the case law?
Yes.
It's not a motion of the court, motion of the defense. No, you just.
Oh my gosh, y'all, I can't. I don't even.
Is he submitting it, or is he just taking it with him?
This woman had already made up her mind 2 weeks ago when she said that 15 years 2 weeks ago. She's terrible. I wonder how long it's going to take to appeal. This is freaking awful. I am Hi butterfly. This is the worst thing I think I have ever seen. I don't think I've ever seen such bias. in my life. I honestly, I don't even know. I don't know. Law and Order, you're in New York. I mean, how does that's insanity. I've never seen anything like this. I don't even I don't even know what to say. I'm actually speechless. I want to cry. I want to cry. Yeah, that's what it looks like. Yeah. So I'm gonna talk to Perna. We're gonna start the GoFundMe again, but I'm gonna have to word it differently. Because they won't let me do a legal GoFundMe, obviously, because they're against doing any sort of raising any legal funds. If you haven't already subscribed to the channel, please do so. If you haven't hit the like button, please do so. If you haven't if you want to, I'm not monetized, you guys. So if you want to buy me a coffee, please buy me a coffee. I do have that on my channel. It means, hi, Elizabeth, welcome. It means he could serve up to 15 whole years for lying to the frickin' police. So, yeah, I'm going to do, because they took his car, they took his whole life. He had a job. Like even the Department of Corrections suggested in his PSI, to serve probation, even the Department of Corrections. And normally they go by the suggestion of the PSI. She didn't even discuss the PSI in this entire sentencing. So I'm just really upset that this is what she did. So I'm going to talk to Perna. I'll talk to Brian. I will. I mean, it just, I don't know. I'm going to ask Perna how long the appeal will take. But she said it. She said it 2 weeks ago. She said 15 years. And this is absolutely, like, I've never seen anything like this. So I can't believe it's a misdemeanor. I mean, they did a PSI. Okay. A PSI is, like an evaluation. Okay. They look and see, what a flight risk you are. They look and see if you have a job and a place to stay. They look at your past. They look at the level of the crime you were convicted of. They look at all of these things, and they look at your behavior in jail. They look at all of these things and they put it together, and that's what they decide. If you're a good candidate for rehabilitation. Yeah, that was very rude of her. She said that he lied on the stand, and that was very uncalled for. And you saw Brian's face. That was pretty jacked up what she said. So they're stuck with this judge till 2027, you guys. She's on the bench till 2027. She fought that dismissal, but she had no choice because it's a Supreme Court decision. And she couldn't go against the Supreme Court, and she wanted to, man. You saw how she argued. She even argued the Supreme Court. So, but it's just sickening. I don't even. So I will let you guys know about the new GoFundMe. I'll talk to Perna. We'll work on that, but we're going to have to start raising some money for his lawyers, because he has to pay. He's got to pay for the appeal. These lawyers are paid. They are not court appointed. And in order for him to continue this fight, we have to raise money. So this can't, it doesn't stop here. I will just note that Jeff had his head down the entire time until Brian made that point that people lied on the stand. They committed perjury on the stand, and Jeff put his head up, because we know Jeff's a liar. So yeah. Yeah, I've shared this, Kirsten, with every true crime channel. I've tagged them, and nobody. Thank you, Ryan. I appreciate you. I have. Hi, Samantha. Welcome. I've shared this with every big channel. They just won't pick this case up. They know also about the corruption in the DA's office. They know as much as I know. I just investigated more. They just won't investigate it. They won't take the story. The synagogue and the politicians there have a very, very deep. They're embedded deep into this. So I'm the only person talking about the corruption up there, and I'm in Austin, so it's really it's difficult. So I've been telling people on the channel, like, if you don't see me anymore, if you don't see me coming on here anymore, it's because something happened, and you can look in Detroit for who did it. So but there's a lot of money involved. There's a lot of things happening behind the scenes up there. And it has to do with the synagogue, and it has to do with the Jewish community. And it's really sad to say, but that's just how it is. But that judge is in her position for many more years. Yeah, it's terrible. I can't believe that this. Yeah. So what's sad is that, Kim Brown, Kim Worthy is she's Black, but she's put more Black men in jail up there than anyone else as district attorney. And she's very proud of her numbers. So it's just disgusting. Nick Straw. Okay, I'll look him up, Eve. There's a couple of more YouTubers, that have done this trial. So I will look them up and see if they can also help me with some funding, some crowd, like trying to do the GoFundMe, like get the GoFundMe out. I just got to talk to Perna about how to get the GoFundMe going better. Yeah. And it just sucks. I mean, we all make mistakes, we all do dumb stuff when we're young. And I mean, it's just dumb. I really hate that the prosecutor said that he just likes to commit crimes. That's not true. Unfortunately, it's Detroit. It's hard to afford to live there. And I'm not excusing his behavior by any means. I mean, my God, my job used to be to catch shoplifters. So he wasn't out there because he enjoyed committing crimes. He was out there because he was really looking for something to help get by. And I know that doesn't excuse his behavior, but it wasn't because he enjoys committing crimes. I know that. Oh, I know who you're talking about. Eve. Yeah. Yeah. Yeah, it's he was actually out that night, really looked like, again, not excusing what he was doing, but he was actually out that night just looking for ways to just, kind of like the glasses that they brought him in for, the Cartier glasses. I mean, that was just something that they happened upon, and he pawned them to just have some money to pay bills. Yeah. So that's again what he was just kind of doing that night. He was just looking for something that he could kind of pawn just to make some money to pay some bills. I mean, yes, they both work, but again, we're in a really tough economy right now. It's hard to make enough money to pay bills. I mean, and especially in a city like Detroit, uh, where the entire community there is being gentrified, and they're being kind of pushed out because it's too expensive to live there. Yeah. And it just stinks. I don't even, I mean, again, we all look in the mirror at ourselves, and look at back what we used to do when we were younger, I mean, we should all be in jail probably. We should have all been arrested for something. I just can't believe, I'm going to look up. I did look up, for lying to the police is 93 days and a $500 fine as a misdemeanor. And that's what he was a misdemeanor. But she's taking into account, Kirsten, seriously, just because you're in Germany, honestly, you signing the petition, like, don't think that you can't do much. You've done a lot. Like, signing the petition. Michael is very, very appreciative, you guys, of all the support. You have no idea. So don't think that because you're from a farther place that you haven't impacted this at all. Trust me, it's been a huge impact. Just know that he knows about all of your support and all of the prayers and everything. He loves this channel. So don't think that he's not aware and doesn't know that everyone is supporting him from all over. So this is just a big blow today. It's going to be huge. This is huge. No, he did not. He did not have a fair shot. And that is what sucks. But I don't want us to get discouraged by any means. This is a huge blow, obviously. I'm very saddened. And I know you guys are too. But we're not going to stop. It just takes one person, you guys. It does. It only takes one person, and then, to make a difference. So we have this great group, and we're gonna make it happen. That's right, Trial Junkies. It's just beginning. This is just one more hurdle that we have to get over, and we're gonna make it happen. I mean, yeah, I'm gonna message him too. I'm gonna message everyone and just see. The YouTube community is supposed to be a community, so I'm gonna do the best I can to get in touch with as many people as I can. So that's what we're gonna do. I know, Ryan. I am. I'm really sad, but it's we can't let this break us. So we have to stay strong for Michael, and we have to keep fighting. Yeah, you're right, Gwen. We're gonna have to keep fighting. There's God doesn't like ugly, okay? And that judge was being ugly, the prosecution was being ugly. They fought dirty, but you know what? In the end, that won't win. So let's just keep praying and keep pushing for the best. We're gonna something good is gonna come Michael's way. It's gonna happen. So karma. Yep. Which info is it? Trial Junkies? I'm sorry. Oh, the Michigan law. I'm going to start digging around. I'm going to talk to a couple of attorneys up there. I'm going to talk to Perna. Yeah, I'm trying really hard, Trial Junkies. And I'm going to talk to Lillian again. Yeah. Man. What is, let me, is that the name of your YouTube channel, Trial Junkies United? Because when I look you guys up, I don't get the same. I don't get the same. Yeah, I'm going to see if I can get, yeah, when I look up you guys's, oh, okay, Facebook. Okay, I'll look you up on Facebook then. Okay, I'm going to let you guys go because I have to get in touch with Perna and some other people and get things going because I can't stop right now. So I'm glad you guys joined. I'm sorry this did not go the way we wanted it to. But again, we're just getting started. So I need you guys to stay on point. Okay. And we're not going to stop this trial. We are going to continue other trials, but we're not going to stop fighting for Michael. Okay. This is our main focus is fighting for Michael. So I will keep you guys posted on it. Next week, we have more trials to look at. I will be traveling to Arizona next week to see my sisters. So I will be on location. But I'll let you guys know what I find out. And we'll see what we can do. Okay. And I'll keep you posted I'll let you guys know when I do another live, Ryan. Don't worry. Are you on? Don't forget to hit the notification bell so you can know when I'm going to be on live. Okay, Ryan. And I will let you know. Thank you so much, you guys, for getting on. And I really appreciate it. Yes, Ryan, we are. I so appreciate you guys so much. And I'm praying for you guys and just keep it together. We're going to get this. We're going to figure this out. Even if that means I have to go to Detroit. Okay. Thank you so much, you guys. I appreciate you all. I will see you soon. God bless.